والآن نبدأ الجلسة الثالثة بعنوان التقاضي والتحكيم، ورئيس الجلسة مريان كولدس، وندعو المتحدثون مستر إدوارد كويج ومستر جياكومو روخاس.
You need a break or shall we start? محتاجين بريك ولا هنبتدي؟ مساء الخير على حضراتكم. Good afternoon, everyone. It's with great pleasure and honor that I stand before you today to introduce Dr. Giacomo and Mr. Edward Quigg. We talked about very interesting topics, smart villages, and we talked also about the sports, but now here comes to an important also topic. We cannot have any contract without a dispute resolution clause, whether we like it or not. We try to avoid it, but still we have to have it. And the real problem is that we always call this clause the midnight clause. We just forget about it. And when we have the contract concluded, we don't like to think about it, but we have to. We will talk today about the dispute resolution clauses, but before talking about this topic, I gave a small introduction because I wanted really to have the people's attention before introducing our guest speakers. Let me introduce you or Mr. Edward. You first? Okay. Okay. So Mr. Edward Quigg is a remarkable individual whose presence in our midst is a testament of excellence, dedication, and achievement. Mr. Edward is the director and owner of Quigg Golden. He is an arbitrator and mediator, a fellow of the Chartered Institute of Arbitrators, and a freeman of the Most Worshipful Company of Arbitrators of London. Mr. Edward has taken part in revising the unilateral model arbitration rules in the UN, has represented parties in over 500 arbitrations, including ICC international ones. He has been appointed as an arbitrator in ICC and various schemes. He issued over 30 awards. Furthermore, Mr. Edward is competent in the adjudication process, having been involved with over 1,000 successful adjudications. A past chairman of the Adjudication Society, he drafts procurement policies and tender documentation and assists bid evaluation teams to mark bids fairly and in accordance with stated criteria. Finally, Mr. Edward has represented many private clients in relation to challenging procurement processes of very high value. Please join me extending a warm welcome to Mr. Edward as we eagerly anticipate the wisdom, insight, and inspiration he will undoubtedly share with us today. Thank you very much.
Going by that very kind and generous introduction, I think I must be getting quite old, and if I've done all of that work. So what do I want to talk to you briefly about now? And the title of this session is looking at arbitration and litigation. And something has changed quite dramatically in the United Kingdom in relation to how we resolve construction disputes since I started doing it about 25, 30 years ago to today. When I started out, any construction dispute was dealt with by arbitration. That was the default process that all of the standard form contracts in the UK dictated. But that's changed now, and you virtually have no domestic arbitrations in the UK. The arbitrations we'll have in the UK in the construction industry are international arbitrations. We'll still act as arbitrators, and still our lawyers like working and representing clients around the world, but in domestic UK contracts, arbitration has effectively disappeared. And the standard form contracts, such as the Joint Contracts Tribunal, the NEC, and so on, do not make arbitration default. The default process is litigation. And because that is quite a big shift, I wanted to try to understand why that's happened, and then to maybe ask the question, is that something that might happen in the GCC or in this market? So the way I'll go about it is identifying some of the key differences between arbitration or litigation, and then considering where we sit with it. So the first has to be the choice of the judge or arbitrator. If we go to court, we will have imposed upon us a judge. And that judge, certainly in the UK, will be an ex-lawyer, generally a barrister, who has operated in that field for a number of years. Whereas if we go to arbitration, we are likely to have an arbitrator appointed who might be an engineer or an architect or a quantity surveyor, could even be a lawyer as well. But there's a much greater range. And the perception was always that it was far better for us in the construction industry that our disputes should be dealt with by an experienced engineer or architect and not by a lawyer. If we're going to dispute how long it takes to build a bridge, what would a lawyer know? An engineer might know. However, there are other differences in terms of the choice rather than just their discipline. There can sometimes be a concern in relation to bias. If we are taking someone from the industry, it's likely that one or other of the parties will have had previous dealings with that person. It could be a national perception of bias. So if the works are located within England, one party is English, one party is Italian, could there be a concern that if an English arbitrator is appointed, he would favour the English party? That's a concern that people can have. Cost can be a concern. Now, although whenever we're talking about mega projects, the amounts in disputes are likely to be very high. But let's not make any mistake, arbitration is not cheap, and some of the arbitrator fees that are charged are quite high. If you go to the ICC, you may have to pay $100,000+ for your arbitrator, and there's 3 of them. If you go to court, you pay one fee, which is $10,000, and that's it. That covers all of the charges. So that is a significant side of it. So, what else then separates or differentiates arbitration and litigation? Another one we'll talk about is flexibility. Arbitration is a very flexible process. Depending on the nature of the dispute, we can go from what I've called a look-sniff arbitration. So if there's a dispute in relation to the quality of a material or grocery, the arbitrator can come, inspect it, and make an immediate decision. So an arbitration could last several hours. Or, of course, if we're dealing with a final account dispute in relation to a mega project, it may take 4 or 5 years to resolve. But arbitration can cover all of that, from a very quick decision on a neat point to something much more complicated. And the courts traditionally in the UK couldn't. They weren't as adaptive as that. And that's changed in the UK, and one of the big changes, I think, which has driven this, was the introduction of something called CPR. Won't bore you with the detail of it, but the courts now in the UK can be very flexible. There are processes where I can apply to the court to enforce a decision of an adjudicator, and I'll get that done maybe within 28 days. Whereas it used to be forever. So it's flexible at speed. We've talked about cost briefly. In terms of the parties' costs, there's not much difference between arbitration and litigation. They're broadly quite similar. The ability to appeal a decision. One of the advantages, or perceived advantages, of arbitration is once an arbitrator makes an award, it's very difficult to appeal it in nearly every jurisdiction. Whereas if you get a High Court judge's decision, there is a Court of Appeal above that and a Supreme Court. But actually, do we really think that's an advantage? Arbitrators can get things wrong. We can have a rogue decision. So actually, whenever there's a serious dispute, our clients sometimes say, well, what happens if we get a bad decision? Can we go to another tier above? And I say in arbitration, no, we can't. And they don't actually like that. They want to know that there is a possibility of moving it on. Two other aspects worth mentioning. One is in relation to remedies. An arbitrator really can't award a remedy other than money, whereas a court can issue injunctions and issue other remedies other than just an award of damages. And very lastly, if we have multi-party disputes, there is a suggestion that court is better placed to deal with it. So if there's a dispute in relation to the quality of the roof, which leaks, perhaps the architect is being blamed for the design, the contractor is being blamed for the work, he's blaming the subcontractor, who in turn is complaining about the supplier. Well, the court's quite used to having a multi-party dispute, so having all 5 parties in the one dispute. We can do that in arbitration, but we need agreement. We need each party to agree to that, and it's unlikely to get agreement from each party. So, to summarise that then, why has the UK construction industry turned away from arbitration? And I think the answer to it is that they have now been given a court system in the UK that is fast and is relatively cheap and is impartial. And the construction industry has preferred it. So I ask then one other question, well, why is the court system suddenly improved? Because believe you me, it's not through funding from government. They're not well funded, the court system. But the UK introduced another process about 20 years ago called adjudication. It's not part of what we're talking about today, but every construction contract, in every construction contract, a party has a statutory right to refer a dispute to an independent third party who will make a decision within 28 days, and that decision is binding on the parties. It's binding until a judge or an arbitrator determines it otherwise. So you could call it an interim measure, and that's what it was designed to be. But we, James and myself, we've conducted over 1,000 adjudications, and I think only about 5 or 6 have gone on to arbitration or litigation. So what's happened is the workload that was coming into the courts in London dealing with construction disputes disappeared. They didn't have these big cases that were taking up the time. As a result of that, because the workload has dropped off, they can deal with things very quickly. So, to conclude, the UK industry has turned its back on arbitration and has decided to use litigation. Is that likely or possible to happen in GCC? And I'm not sure it is, and that's for 2 reasons. One, we don't have adjudication, and therefore the courts, in part, are still not as efficient as we would like them to be. And the second issue is that, or a second issue, is we have to keep our quality of the arbitrators up. Now, I noticed that one of the sponsors, which is the GCC Arbitration Centre, you'll see brochures on your desks, and they're heavily promoting the issue of having fellows and then those people having to go through another exam before they are entitled to sit as arbitrators. So I think here, if we can keep the quality of the arbitrators up, the parties will have belief in the process, and it won't be the same as the UK, and that people won't turn their back on arbitration. But that's very much some thoughts for you to think about. And then after my colleague gives you some thoughts about arbitration litigation, it's something maybe you could tell me what you think, whether or not that's likely or not. But for now, thank you very much.
Thank you so much, Mr. Edward. And now let me also please introduce Professor Giacomo. Professor Giacomo Rojas is of counsel and co-head of the arbitration practice at Chiomenti, right? Yeah. He is an associate professor of private law at the Rome Tre University Law Department, a dual qualified lawyer. Let me first say that it's a great pleasure and honor that to be with you today, Professor Giacomo. He's an associate professor of private law at the Rome Tre University Law Department. He's dual qualified lawyer in Italy and New York. Mr. Giacomo has earned both his law degree and his doctoral degree from Rome Tre University, and he holds an LLM with distinction and an SJD from the University of Pennsylvania Law School. He is actively involved in commercial and investment arbitration as counsel, expert, witness, and arbitrator. He has been appointed as an expert by the Italian Republic in several investment arbitration proceedings under the rules of exit and SEC, and by multinational corporations before the US state and federal courts. He has served as co-editor of the ICCA project, Does a Right to a Physical Hearing Exist in International Arbitration? In January 2023, Mr. Giacomo has been appointed by Italy to the exit panel of conciliators for a 6-year term. Please join me in extending a warm welcome to Mr. Giacomo, to Professor Giacomo, as we eagerly anticipate the wisdom, insight, and inspiration he will share with us today. Thank you.
Thank you. Thank you, Dr. Caldas, for your very generous introduction, and once again, thank you very much for having me here as a speaker. It is an honor indeed. So in the next 15 minutes, what I will try to do is to answer some questions related to international arbitration and mega projects. In particular, 3 main questions. The first one is, why do we resort to arbitration, or first to alternative dispute resolution methods instead of going to domestic court? Which alternative dispute resolution methods are more appropriate for mega projects? And the last question would be, what, if any, characteristics identifies mega project arbitration as compared to a standard international commercial arbitration? Is there any difference from a standard commercial arbitration and a construction arbitration related to a mega project? So before addressing these 3 questions, just a short introduction on the background. So we have heard yesterday in particular and today that we are dealing, when we spoke about mega projects, we deal with a word that is characterized by multi-parties. We have several actors involved, not only the owner and the contractor, but the subcontractors, the suppliers, the lenders, the designers, architects, etc. We have, so multi-parties, we have multi-risk. In a mega project, we have heard yesterday, normally they last for an extended period of time. There may be increases of prices, regulatory changes, force majeure events, so we have to properly allocate multiple risks. And then we have multiple claims. Normally, if there are disputes, it's not just one dispute arising out of a mega project, but multiple claims. So multiple parties, multiple risks, multiple claims. As to claims, which is obviously the basis for a dispute and for an arbitration, we have to distinguish between the contractor's claims and the employer's claims in particular. And just very quickly, contractors' claims are normally related either to the extension of time and additional payment. Extension of time normally is not per se a claim for more money, is normally a claim in order to avoid to pay money to the owner. The contractor requests more time in order not to pay liquidated damages. So the extension of time claim is not immediately a claim for more damages, as it is the claim for additional payment, which is either related to the extension of time, so prolongation cost, or to the other reasons, for example, the interference from the owner, which doesn't allow the contractor to perform properly, and these are called disruption claims. Moving to the employer's claims, we normally have claims related to, again, the extension of time for the notice, defects notification period. So the employer needs to notify when it detects defects in the project, and sometimes it needs more time to do that. Claims related to liquidation damages, and obviously damages deriving from the breach of the obligation by the contractor to, for example, remedy the defects. Now, considering that we are dealing with so many different claims, it is key in a construction and in a mega project to properly manage these claims during the project, because otherwise it will be very difficult to bring these claims in an arbitration at a later stage. So management procedures, both during the project and before commencing the arbitration proceedings are key. And there are now also softwares helping the parties to keep in good order all different claims arising out of a project. So now coming to my three questions. So why ADR, alternative dispute resolution, in mega project? Edward has addressed some of these points before. One reason, for example, not to go immediately before a judge one reason not to commence immediately an international arbitration may be the idea not to interrupt the works. So the idea is comply now and argue later, and postpone the litigation to a second moment. Another reason for looking at alternative dispute resolution method may be the need to have some engineer deciding the dispute instead of a lawyer, instead of a judge. So an expertise in a very niche technical field. As Edward said before, one other reason is the goal to, the objective not to have multiple instances as you have when you go before a court. So the attempt to decide everything in one single stage. And also having common rules that are known to both parties. If parties comes from different countries, they both want to avoid local domestic procedural rules. So resorting to an alternative dispute resolution method may be a way to avoid to be attracted by a domestic system. So when I say alternative dispute resolution methods, I don't only have in mind, of course, arbitration, and I will get to arbitration in a moment, but other methods as well. Now, it is very common to find in complex construction contracts so-called multi-tiered clauses. What does it mean, multi-tiered clause? It means that a party cannot immediately commence an arbitration. It has to either first attempt a mediation, for example, so you have mediation plus arbitration, or you have something very similar to what in the English court is called adjudication. You have so-called dispute boards. The FIDIC contract now provides for the DAB, the Dispute Avoidance Adjudication Boards. Now, what is the role of dispute boards and what is the relationship between dispute boards and arbitration? Normally, in these multi-tiered clauses, dispute boards are a condition precedent in order to commence an arbitration. In other words, you cannot commence an arbitration if you have not resorted first to a dispute board. A dispute board is a panel composed either of 1 or 3 experts that will provide a decision or an advice. An advice is not binding, so let's focus on a decision. A decision by a dispute board becomes final and binding only when it's not challenged, is not challenged by parties through a so-called notice of dissatisfaction. So if parties in a construction contract don't like the decision of a dispute board, they have to issue a notice of dissatisfaction. After issuing a notice of dissatisfaction, they can finally commence an arbitration. So you can see why I said before, this is a multi-step, a multi-tiered process. You cannot go straight to arbitration. Another interesting possible remedy that has not been mentioned, if I'm not wrong so far, is the so-called emergency arbitrator. An emergency arbitrator is not an arbitration, is a tool in order to obtain an interim measure, a conservatory measure. For example, you don't want the owner to execute a performance bond and you need a quick decision. You can either resort to a court, or if the institutional rules of your arbitration clause provides for an emergency arbitrator, you can request to this figure called emergency arbitrator to issue an order in order for the owner not to execute a performance bond, for example. And in the complex world of mega project, one of the complexities is what is the relationship between dispute boards and emergency arbitrator, because also dispute boards have interim powers, and therefore one question is whether, if there is a dispute board clause where, you, for example, in a FIDIC contract, you can ask an emergency arbitrator to issue such an order, or you have to do that before a dispute board. But I would leave this question with a question mark. Now, focusing on arbitration, the question I was asking was whether there is any characteristic, any peculiarity when we deal with complex construction projects vis-a-vis standard commercial contracts. I think the answer is yes. I think construction arbitration is a very special animal compared to a standard commercial arbitration. First of all, because as we have said many times, here we deal with multiple contracts, and Oftentimes, even though, as said by Edwards, we need the agreement of multiple parties to be joined in one single arbitration, we have a multi-party arbitration, not an arbitration between only one claimant and one respondent, but several respondents, for example. And so we find in institutional rules instruments such as the joinder or the consolidation in order to reunite more arbitration, more dispute in a single proceedings. Then another feature of construction arbitration that I think is relevant is the huge amount of documents that is normally involved in a mega project. Now, dealing with such an enormous volume of documents imposes to the arbitrators to have a very good management skills and a very proactive, and to exercise a very proactive role. So management of documents is not only something that the parties have to do ahead of the arbitration, it is a big issue during the arbitration proceedings, and it becomes even more complicated when in arbitration is applied the discovery. So when in arbitration we resort to a more common law style, and we can also collect documents through discovery from the other party. Another characteristics is, as I said before, is multiple claims. Oftentimes in complex construction arbitration, it is used something called the Scott schedule. The Scott schedule is an Excel file, is a chart where you put all your claims one after the other in a very simple way in order to make sure that hundreds of claims are not lost in very long briefs, which will become hundreds and hundreds of pages. It is normally a good advice to use this so-called Scott schedule in an international arbitration. Final point, and then I will be happy to go back to any of these aspects during the Q&A time, is the role of experts. So in complex construction arbitration, there is normally the involvement of experts, not only, as we may think, one expert, but multiple experts, either on law, because maybe the arbitrators have to apply a governing law of the contract that is not their own law, so we may involve experts on law, but more often experts that are either expert on technical aspects that must assess, obviously, defects or delay, the reasons behind a huge delay in a construction project. So delay analysis is one very important aspect. And then so-called quantum experts, experts that have to deal with the quantification of damages. So, of course, we will have many experts involved in an arbitration, and here, and this will be my last consideration for now, is again the tension between the common law and the civil law tradition. As I mentioned, for documents where there is the possibility of discovery in some arbitration, here also the role of experts may change if we either adhere to a more common law style, and so we only have party-appointed expert that we will engage in a so-called battle of experts, and then the arbitral tribunal will decide which expert is more reliable than the other, or, and this is more rare in international arbitration, we have tribunal-appointed expert, which is more similar to the civil law tradition, where we have an expert appointed by the tribunal that will eventually advise the tribunal on the technical aspects. So this is another important feature of construction arbitration, and I stop here, and thank you for your attention. Thank you very much.
Thank you, Professor Giacomo, and thank you, Mr. Edward. And I repeat your words. You said that mega projects include multiple claims, multiple parties, and multiple risks. And here comes the importance, really, of the dispute resolution clause, because it is complicated. And you have both also talked about ADRs, like in general, arbitration, mediation, emergency arbitrator, and adjudication, and dispute board, dispute avoidance board. And those are all like processes and tools to make the dispute resolution smoother, but they will not, sometimes they will avoid, but still, it is important to draft well the dispute resolution clause itself. I'll just tell you something like yesterday I had someone calling me because they had a big problem. 8 months ago, they were drafting their contract, and I told them it was like a big construction contract. And I told them, be aware of the dispute resolution clause. So they laughed and they told me, oh yeah, because you're directing an arbitration center and because you come from a legal background, we're on a very good terms and there is no problem. Yesterday they called and they have a huge problem. And now comes the problem that they didn't draft well the clause. So it becomes in itself a problem. So it is important to anticipate things and to be aware of all the tools that we have. But when it comes to mega projects, it is more complicated and it involves many parties. So my question to the panelists is, what in your experience is a good process to have in place to resolve disputes on mega projects? You have mentioned many of them, maybe litigation. It is like you said, Mr. Edward, that sometimes litigation is not costly, is the same in terms of cost as arbitration. But for example, in other countries, for example, here in Egypt, no, arbitration is more expensive. So it's not the same, but in terms of maybe of time, arbitration is faster. So how to really choose between the right dispute resolution tool?
Well, I come from a country called Ireland, and there's a saying that if you ask an Irishman how to get to somewhere, his answer will be, well, I wouldn't start from here. So I wouldn't talk about how to resolve the dispute. I think I would like to look at how do we prevent the disputes from occurring, or at least dealing with them at an early stage. And you mentioned the DAB board, Dispute Avoidance and Adjudication Board. It's an excellent tool if you have the right people appointed to the board. The people who sit on that board should have the experience to identify where disputes may come from and to try to work with the parties to avoid it becoming a dispute. Because after all, a change or a claim for additional time or money is not a dispute. It's only when it's disagreed with does it become a dispute. And there may be an entitlement to it. So I would suggest that trying to have a tiered dispute resolution clause, but having part of that dealing with a DAB board or another phrase, and I get appointed as a standing conciliator. So I'm there from the start of the project all the way through to try to help the parties by identifying things that might become disputes and trying to resolve them at the time. If not, then you have to look to the resolution.
Yeah, I fully share what Edward said. I think it's the key point is to appoint the DAB from the very beginning of the project, because what I have seen in my experience is that sometimes you have these complex multi-tiered clauses in the contract, but the parties did not appoint the DAB at the beginning of the project, and then you not only have a claim, you have a dispute but you have to go through a DAB before commencing an arbitration, which is only adding up cost, because there is a moment where it's clear to both parties that it is not going to be solved amicably. And so sometimes if you don't have the DAB smoothing the process from the very beginning, you also have to consider the additional cost of a multi-tiered, multi-steps clause, which is very useful, but adds also more cost.
Yeah, true. It has a cost, but I think also it prevents and it avoids many disputes. So the cost is much less than also resorting to arbitration in the future. So, but you touched upon like a very important point that they have to appoint this board from the very beginning. And can you give us more information about what is arbitration? Because yes, there are some people from a legal background here, but others are not. What is really arbitration? And does arbitration really have the power, same power like litigation? Do I have like the decision or the award has the same power? Like Mr. Edward, for example, said that it's only, there isn't like another tier, so it's final. The decision is final. So how also do you find this?
Well, in fact, I'll be interested in your take on this as well, coming from the different jurisdictions. But if you have an arbitrator's award, it is generally speaking easier to enforce it in any country in the world that signed the New York Convention on the Enforcement of Arbitrators' Award than a decision of a domestic court. So the New York Convention is where I can't remember now, it's like 130 countries have signed, and they said that they will enforce an arbitrator's award. So I might have a dispute with Samsung, and if I win, then I can see, where does Samsung have assets? Oh, they have assets in Singapore. Okay, well, I'll go to Singapore and I'll enforce it there. Well, they have assets in London, I'll enforce it there. Whereas if that is a decision of a court from Dublin, then I have to actually, it's harder to get the courts in Singapore to recognize the judgment than it is an arbitrator's award, is my experience, but I'd be very interested in yours.
No, again, Edward, I fully share your view. The New York Convention is the 1958 New York Convention is the fundamental element or legal piece that allows international arbitration to work. Because as Edward was saying, thanks to this convention, when you have a final decision from the arbitrators, you can bring this decision all around the world to all the signatory countries to the New York Convention, and you can enforce that decision everywhere. And this is normally easier, as Edward just said, than enforcing a foreign court decision. So that's a big advantage if you have a foreign counterpart in your contract, because you want to enforce the final decision probably somewhere else, not in your jurisdiction, but most probably where your counterparty has the assets. So to answer your question, what is arbitration in very simple words is, of course, a dispute resolution method where parties appoint neutrals, arbitrators, which are independent from the parties, in order to resolve the dispute in a final and binding way. Differently from the DAB that we were discussing before, the DAB decision is not comparable to an arbitral award. You have no New York Convention to enforce the DAB decision. It has the same force as a contractual agreement. So parties are bound to a DAB decision because they decided to follow the DAB decision in a contract. But if they don't do that, is like a contractual breach. On the other hand, an arbitral award is comparable to a court decision. So that's a very important difference between the two.
Thank you so much for this. And we will leave the floor to the audience, but I have a question before. Since we were talking about women empowerment and Dr. Sahar and her speech was really powerful and really we can see her passion. But we have noticed that in arbitration, most of the arbitrators are male, and especially in mega projects and construction projects. How do you see this, and what is the future, and how we can avoid this or correct it?
Well, it is a problem.
Yeah.
It is. And they're old, they're male, and they're grey. And to some extent, there is a reason, and that is because they have traditionally come from the construction professions, which are engineers, and traditionally engineers have been male. Now that's changing, thankfully, and it is good that it's changing. But until those females come through and are senior engineers, they're not going to be arbitrators. But we realise it, and I say we as in Quig Golden, with many other firms. We have signed a pledge that we will, when we are appointing arbitrators, ensure if we're going to propose 3 arbitrators, one of which will be a female, we will make sure we will not use appointing bodies who have all male panels. And there are a few other aspects to that pledge. And it's not a pledge I've drafted, it's a pledge that institutions drafted, which we agreed with and have signed with. And we're not unique with that. I'm not saying we're better, a lot of people are doing it. But it is a problem, and it will only change if we take actions like that.
Great. Glad to hear that you are signing this pledge.
No, I will only add to this that arbitral institutions are doing a good job in trying to balance the number of male and female arbitrators. So if you look at the statistics of arbitral institutions, they do appoint now normally half and half. Parties, so the users of arbitrations are not still very keen or comfortable in not, I don't think because they don't want to appoint women, but because they want to go for the famous name. Right. And because of what Edward was saying, that traditionally speaking, the arbitrators were male. If you want to have a very big name, is normally a male, and so there is a path of dependence. It's hard to change the status quo, but with time, I'm sure this will eventually change.
Thank you so much. And now we leave the floor for the audience. Yeah.
Hello.
تفضلي. دكتور سحر حضرتك تفضلي برضه.
Thank you for this fruitful discussion, of course, because we are also, all of us in different fields, we are so much concerned with arbitration. And we have a point that some countries, as you said, it's not enforced by law in the constitution, because at the end of the day, regarding any issue, anyone can go to the domestic courts, and this is also a problem. But arbitration is growing now because there is a contradiction. For example, the International Football Association or the Olympic Committee declarations, they now go for it's a necessary to be a member in the assembly of the IOC. As a country, for example, you have to go for arbitration. No way to go to domestic courts, otherwise you are out of it. But this contradicts with our domestic laws and our constitution even. Anyone has the right to go to domestic courts, whatever. So I mean, this is a big contradiction and a big problem issue that we are facing now. And we have a lot of penalties from FIFA, for example, the International Football Association, where I am, and Dr. also Magid knows about this because he also licensed as arbitrator in FIFA, and he knows this, and this maybe he mentioned in our discussion. How can we solve this? It should be a must. So we have to change in our constitution, or we have to do something in the parliament to change this thing. We have another thing which means, which adds up to this, to another explanation. Like in the Constitution, they say the respect for all international declarations or the international whatever, we have to respect it. We have to respect it means it's in our Constitution, but they don't take it and they don't explain it this way in the law. It's not mentioned in the law as it means in the Constitution that, for example, in order to be member of the United Nations, you have to accept all the United Nations declarations and, you know, all the duties and, you know, as a country, because we signed that we are a member of the United Nations Assembly. So we have to respect this, and part of it is the Olympic declarations. It's in the United Nations, by the way. So how come all countries who don't respect this and they are in the Olympic in the United Nations, member in the United Nations Assembly, and they don't apply it totally? In some countries, like also in our country and some of the Arab region. So how can we, finally, there's a contradiction. That's why we are messed with this. Thank you.
I would just like to tell you, like Professor Giacomo said, and like, for example, and like Mr. Edward said, sometimes you need to have, like in the mega projects, an engineer in the panel more than like having a judge, because he will know more, or will have more knowledge of the technicalities. So maybe that's why they insist upon having like arbitration as a mode of dispute resolution. This is my maybe my question. For the Constitution, I'll let you know about this.
So it's a very, very important question. Of course, I am not able to advise how to, from a constitutional, Egyptian constitutional law perspective, what to do. But the problem here is that sport arbitration, differently from all other arbitration, is not based on consent. So normally when we enter into a contract, we spontaneously, voluntarily decide to introduce an arbitration clause. In sports, when you adhere to a sport federation, to the Olympic Committee, you have to also accept as a resolution method arbitration. And so you see that here there is a contradiction, because arbitration is based on consent, but in sport arbitration there is no consent. And now the European Union, very recently, the European Court of Justice issued a decision against the skating federation, sport federation, saying that the arbitration imposed by the Skating International Federation is against European law when there is an antitrust, a competition matter involved, because being the arbitral tribunal seated in Switzerland, they don't have to apply EU law. So you have an arbitration in Switzerland where the arbitrators are not applying EU mandatory laws. And so the European Union said this is not okay. So basically you can go to court if there is a competition or antitrust matter involved, because a Swiss arbitration is not going to address EU law. And we don't know what is going to happen, because of course this is very disruptive for the sports arbitration system. And I think it's not so different from the problem you were now raising with Egyptian law. So I think it's an evolving and very current issue.
We have another question.
Hello, good evening, panel. Thank you very much for sharing your expertise. I'm Riham El-Hawari. I'm president of Persona International for People and Organization Skills Development. And you made me very nostalgic, but what you shared. Actually, 25 years ago, I was an arbitrator in a construction company. And I'll tell you how it happened. And this is for all construction companies. Why is it not working? And where is the role of a woman there? I studied in '98 engineering law and contract procedure in UK with Thomas Telford and University of Leeds. This is where the problem is. The success of arbitration or any amicable resolution, you must have an expert from the field. So by being an engineer, because I'm actually an engineer who studied law and then continued in the center of the Egyptian Center of Arbitration, that made it happen. So what I'm asking you is, for especially the construction, because engineers, we have a different mindset and a different way of resolving things. So what I'm asking you through the center in Egypt and your center, sir, is that you need to encourage people from different disciplines, like if you're talking about finance, if you're talking about engineering, construction, people who have this technical information to study contracts and study the law related to this. That would make it successful. And as being a woman in arbitration, it works very well because we do have an eye for details, I must confess. And we have the tolerance to dig things out. So I went into arbitration for cement industry, for constructing a cement plant. And it worked beautifully. Why? Because there was a contracts engineer inside the organization, supervised the contract from the inception of the project, and this what makes it happen. So you need it not only have an arbitration center, we need in each of the organizations, especially if we're talking about construction and mega projects like this, you need an advocate for the concept within the organization. So law, contracts must be taught to people of different technical backgrounds in order to work on this from the very beginning. And you will have your advocates within the organization itself. Thank you. So, what do you think, sir?
What I think is that if everybody did that, there wouldn't be as many disputes, and I wouldn't have a very nice house or a nice holiday. So
thank you so much for your attention, and thank you so much for our speakers, for Professor Giacomo and Mr. Edward. And thank you so much for sharing your expertise, and it was a pleasure having you today. Thank you. Thank you.
يعني كصورة هم تكرموا.
Arbitration against lunch. So, lunchtime. Thank you.